Hi. All right, so continuing on with the law morality summary sheet, so hopefully you've done the first half. We started exploring some themes that could possibly come up in a law morality essay. So one theme could be looking at how law and morals relate to each other. Are they the same or are they different? Another potential theme, and a very strong contender I think, is whether the law should enforce our moral codes. Now, we've talked about the difference between them. We've given some definitions in our introduction. So the idea, should the law be used as a tool to make people more moral? Now, we have two sides of this. One camp says that the law should be used to enforce morals, and we call this natural law. So natural law theorists believe that law comes from a divine source, so often religion. And because religion is our highest power and moral guidance, our laws and rules should be based around those. So I've given three key examples that from your handout, there is more, of people who believed in this. St. Thomas Aquinas, Lon Fuller, and Viscount Simmons, a judge. There was also James Fitzstevens as well. So there's a few others that you could talk about here. So natural law theorists believe that law comes from a natural source, a divine source, a religious source, and it should be followed for those reasons. Therefore, all laws should reflect things like the Ten Commandments. The other side of the debate is that law should not be used to enforce morals, that law and morals are two very separate things, and laws should simply be followed because a higher power has created them. So by higher power here, we mean a higher supreme legislative power. So for example, in the UK, our highest legislative power, well, in England and Wales, is our Parliament. As a society, we've decided that Parliament is the supreme lawmaking authority, so therefore we follow their rules simply because they have made them. Whether they are the same or have overlap with morals does not and should not matter. The mere fact is we should follow them because they were made by that body, whether they conflict with our morals or reinforce them. So key theorists you can talk about here would be Aristotle, Jeremy Bentham, and John Stuart Mill. Now, a really key debate that you need to talk about if this theme comes up is the Hart-Devlin debate. We have Professor Hart, an academic, and we have Lord Devlin, a judge. And they were giving views on the Wolfenden report into whether homosexuality should be legalised. And essentially they split into different camps. So Lord Devlin is a natural law theorist, and he believed that divine sources such as religion tell us that homosexuality is wrong, and therefore it shouldn't be encouraged or authorised by the law. Professor Hart, however, said that as long as people do things in private and they don't bring harm to others, then there's no reason for the law to restrict our personal freedoms. A really key case that you can talk about here, of course, is R versus Brown from 1996. Lord Devlin believed that what the men were doing was deviant, it was morally wrong, and therefore the law was right to find those men guilty of the non-fatal offences that they were. The law should discourage such immoral behaviour. And if we make such behaviour outlawed, then people will do it less. Professor Hart, as I said, believed in autonomy, that we are adults who make our own choices, and as long as no one is harmed, they should be able to do what they want without interference from the state. And if you remember in R versus Brown, none of the men were harmed to the extent that they sought medical attention. So the Hart-Devlin debate is really, really key. This is an ongoing debate, and hopefully in your handout or thinking back, you can think of laws that show natural law theories and ones that show positivism. So for example, the case of Donahue versus Stevenson is based on the neighbour principle. Love thy neighbour. We were talking about avoiding actions which may harm our neighbour. That is very much a natural law stance, because of course the idea of loving thy neighbour comes from the Bible, it comes from religion, and therefore we should follow that theme through into tort law. Positivism tries to set aside personal moral feelings and apply the law as it is, as it has been decided. So the judges may not necessarily agree with the decision, but they force it anyway because it applies the law of a higher power. LNER versus Berryman, for example, shows this. You could argue that the widow not getting compensation because her husband was wasn't relaying or repairing the line, they were maintaining it. You could argue that's morally wrong because there is very, very little difference. However, the judges took a positivist approach. The law is stated by Parliament, they are supreme. We interpret it literally, and that was the outcome. Whether it's morally right or wrong, it doesn't matter. So another issue that is probably going to come up as a theme with both of those is that the idea of law and morality in the relationship between the two mostly works if we have one single shared common moral code. So the law could possibly enforce a moral code that everybody has. The difficulty with the United Kingdom is pluralism. We don't have one single common set of shared morals. Our culture is made up from people of different backgrounds, of different ethnicities, different religions, different upbringings. We all have slightly different moral codes. So if the law was to make morals a thing that is punishable by law, whose morals do we pick? Because my morals might be different to yours and different to the person in the next town over. So whose morals do we choose to put into law and whose do we leave out? And that's a very, very complicated question when it comes to having a pluralist society. I'm not really convinced it can be done very effectively with a pluralist society, but that is what our society tries to do. And I think a lot of that is based on the theory of utilitarianism, which is something that John Stuart Mill and Jeremy Bentham talked about. And this is the idea of trying to do the greatest good for the greatest number. So not everybody's preferences, not everybody's morals are going to be reflected in the law because everyone's is different. But what we'll try and do is make the best laws we can for the most number of people. So we can try and make most people happy. Now you could argue R versus Brown was an example of that, trying to make most people happy by keeping them safe. However, it ignores the rights of the individual. So it ignores the rights and the beliefs of those men who were enjoying what they're doing and didn't see anything wrong with it. So lots of different things you could talk about. You can talk about areas of all law when it comes to this. Contract law is harder, but remember with contract law, we do have some moral questions such as promissory estoppel, the idea that if you've made a promise to write off a debt, you're held to that, even if it goes against contract law. Or you could argue the rights of third parties, of privity. For example, Jackson versus Horizon Holiday was an example of natural law where we try and make the law fair for everybody, that we try and enforce a moral code that the whole family should have been compensated. You can also talk about the criminal law procedures, so how a trial runs, and also sentencing. Should sentences reflect morals? So for example, if a young mum steals to feed her starving children, is it right that the law enforces the punishment harshly? Or do we take a moral standpoint on this? Or if it comes to, for example, assisted suicide, that's a big area where we could talk about law enforcing morals and the difficulty with conflicting religious views. Then what you need to do, because it has an asterisk in this question, is conclude. Now, a conclusion needs to have 3 key elements. for it to be a valid conclusion. Remember, that's what you need for level 3 and 4. 3 things. Refer back to the question. Use the words from the question. Actually answer the question you're being asked. Summarise both sides of your argument. Maybe pick 1 or 2 from each side. So for example, if the essay question is asking you, should the law enforce morals? Sum up 1 key argument why yes it should, and sum up 1 key argument why no it shouldn't. Summary, remember, you've already included the information. Don't repeat, you're wasting time. And then you need a final statement. That's because the question is usually asking, discuss the extent to which it is asking you to make a decision. Now, as with other essays, frankly, as examiners, we don't care. We don't care whether you think law should enforce morals or not. There isn't a right answer. Answering yes or no isn't going to get you more marks. What gets you the marks is saying yes or no and explaining why you think that. Why have you come to that based on your whole essay? That's what gets you the marks. I hope that's clear. And it's a really fun essay, believe it or not, because you have a lot of creativity. There isn't a set answer and there isn't a set template. You can use any example that you can think of. It's not an easy one to revise for. Essentially, you're revising the theories, but you can link any example that you think of on the spot. So if you're doing whether law should enforce morals, have a think of any of the cases that you've studied over the last 2 years where you think the law is enforcing morals or not. So for example, the use of self-defense for householders, the fact that they can use more force, is that enforcing morals? Or you could talk about vicarious liability and the fact that you can sue for sexual abuse by priests. Is that the law enforcing morals? Lots of things to think about. Thank you.